Good evening, everyone. We apologize for the delay. We had some technical issues with the cards trying to enter the building, but here we are. Thank you for joining us for this WiCCD CPD on sex assaults in the specific context of jury trials with Marco Sciarra, who's generously, as always, taking the time to present for us this week, and in a few weeks, again, part 2 on this subject. Marco needs no introduction. He is a very well-known and established criminal defense lawyer. He, as you know, if you've probably watched the interview that I did with Marco for Who Cares, he is someone who adores jury trials, and it's becoming a niche for him. And so he will be talking to us today about what he enjoys the most. It's jury trials, but in the context of sexual assault trials. So he has some tips that he will be sharing with us today. He will also have materials that he will be sharing with us after this presentation. So I will let Marco start the presentation. And just one thing, this session and the next one will be recorded. Good evening, Marco.
Thank you, Maya. Thanks everybody for having me here. This is going to be a two-part session. The way we broke it down is today we'll be discussing the pre-trial applications of the sex assault jury trial. And then in part 2, we intend to discuss more of the application. Sorry, Roots is giving me a message saying everyone needs to mute. So that means you, Maya.
I am unmuted. I don't think it's Maya. I think it's other participants actually who have their things unmuted.
Oh, thank you. I'll just wait a second. Is that better? Okay, so we're going to talk about the first.
Marco, you're muted again.
Mine keeps getting muted. I'm okay?
I don't see you as muted.
Yeah.
All right. So start again. It's a two-part series. Tonight, we're going to discuss the pretrial applications. In the next portion, we'll discuss the application of techniques in challenging the evidence in the trial and closing addresses. I invite participants to offer me any questions they have for that portion. Just talking points. What I plan to do is go through about an hour of talking points that I've prepared, and then reserve the back half for the last 30 minutes or so for questions, if anybody has any. The 5 points that we'll discuss, and I'll put them up on the screen shortly. The first will be when to elect to have a sexual assault trial. The second will be Crown applications under Section 486.2 sub 2, which are testimonial aids. The third will be Crown applications under 715.1 of the Criminal Code, which is the application to adduce video evidence of the complainant, there's prior statements. The fourth will be the obvious one, which is the defense evidence, defense applications under Mills, JJ, and the 278.1, 276 style applications. And then finally, I'll just try to get to a part of jury selection and the jury selection process. All the materials and things that I'm referencing here tonight will be made available to you by Maya once the session is done. But I'm just going to share my screen right now and just put them up on the screen to follow along. It's okay, I got it. Is that sharing? Are we good? Okay. So the first thing I'd like to discuss is when do you want to elect to have jury trial in a sexual assault case? Now, obviously, there's no hard and fast rule. I think the first question we always need to ask is, can the client afford a jury trial? I think client resources are always something that should be paramount in preparing a defense, because obviously the cost of a jury trial is going to be significantly higher than that of a judge alone trial, given the length of time it takes and how pretrial applications are constructed these days. The other thing I'd like to mention on that note is sex assault trials generally are becoming more and more costly for our clients, given the state of the law and how these applications have to proceed. So I would really recommend and strongly recommend having these discussions early, because, you know, if your client walks in and says, well, you know, we were in a 5-year relationship and I have, you know, 5,000 text messages that refute this, well, there's going to take a lot of time to go through those messages, and we need to be paid for our time. So that is something that the clients need to be aware of. So I think that, you know, you should be having these conversations very early on with respect to your client and how they want to attribute their resources. The other thing I'll stay at the outset on this issue is, it could be that there is some information in those messages that could be helpful. Maybe it is, maybe it isn't. You need to get a better sense of it, but you have to get your client to sign off on whether or not they want to go down that road and whether or not it's an application that they want to pay for. And if it is something that they can't afford or they don't want to pay for, it's something that's not in their wheelhouse to do, I think you have to get written instructions that there is, you know, good evidence here that can be used. The application is going to cost this much to apply to under 278, 276 to lead this evidence. This is how many court days it's going to require. This is what's going to be involved. And really, I think it's the client's decision as to whether or not they're going to proceed with that application, depending on the cost of it. So these are important conversations we need to have early on. Obviously, for the purposes of today's discussion, though, we're going to assume that the resource issue has been addressed and the client is prepared to proceed with a jury trial. So you want to find out, first of all, are the offenses for which is charged, are they eligible for a preliminary inquiry? I think that's an important consideration, because if there is a preliminary inquiry, then you have that benefit of that preliminary inquiry opportunity to cross-examine the witness, and obviously building a transcript at the preliminary inquiry of their evidence is really crucial in sex assault cases or sexually based offense cases, because that the cross-examination at the trial of transcript testimony, it's very difficult for witnesses to remember the details that they testified to previously. And it's important, if you do have that preliminary inquiry, to elicit those details, the particular details about how the offense took place. You know, if you watch experienced counsel do this, and we'll get into this probably more in the next session, but they elicit a lot of details of the actual event itself, in terms of positioning, where they were, where was his hands, where was her foot, where was this, where was that. All of that's important, because all those details build into a transcript. It's very difficult for a witness then to recall that at trial in the same way. And obviously, cross-examination of prior transcripts is hugely effective in front of a jury if done properly. So that is probably one of the main considerations. You have to be mindful of the fact that a lot of times in sexual assault cases where you do have prelim eligible offenses and you do elect to have a preliminary inquiry, you might face a Crown application to prefer an indictment, or sorry, a Crown might prefer an indictment just to avoid that double cross of the complainants. But nonetheless, if you do get the chance at the prelim, I would recommend to take it. The other thing you might want to ask yourself is this a first offender or is it a repeat offender? If he's a repeat offender, is there a possibility of a similar fact application or not? This is a double-edged sword. It cuts both ways. If there is a similar fact application, the judge might use that, have that information and might use that against your client. Or if it's a similar fact application that is, not something that's going to be successful, you might consider running that, challenging that application as a pretrial motion and running it in front of a jury. Or if it is a similar fact and it is successful in the sense that it gets to be put before the jury, but the offenses are not that similar, you might consider running it in that way in front of a jury, just because in some cases the Crown will suggest that things are similar when they really aren't. And even though the evidence is prejudicial against your client, you might be able to use that distinction to demonstrate that the Crown maybe is grasping at straws. And of course, the judge will have to make a strong charge on to the jury as to whether or not they do find that the offenses are similar enough to use one to establish liability of the other one. Is it an identification case? That's an important factor as well. Oftentimes, identification cases are the types of cases where historically they said, well, that's the type of case you want to run judge alone. I mean, you might have an identification case in this particular sexual assault, but if the guy is a repeat offender and the judge knows that, I think the identification issue starts to become harder to prove or harder to advance in a judge alone trial, whereas a jury will never find out about it, about his prior history, likely, and you might be more successful in that case. Is it never happened case, in which case it's not a consent issue, it's an issue of straight credibility of the complainant and whether or not her story checks out. Is it something that you can challenge thoroughly in cross-examination and basically requiring just your client's testimony as to the denial of it ever occurring in that way? You might want to ask if it's a consent case. Is it the type of case where your client is going to have to testify that she did consent or he did consent in the circumstances, and she is or he is, in terms of the complainant, changing their mind at a later time as to whether or not they consented? Is it a mistaken belief in consent where your client was of the justified belief or mistaken belief, but he felt he was justified in believing that consent was present when it in fact wasn't? Those are the types of issues that can spill into these other applications. So these are the types of questions you want to ask at the outset as to whether or not this would be the type of case that will play well in front of a jury versus the type of case that you might want to re-elect in a judge alone scenario. I know Maya keeps telling everybody that I love jury trials, which I do. I like to do them, but I'm not going to do them just for my own benefit. It has to be in my client's best interest, of course. And in sex assault cases, there are a lot of sex assault cases which I run judge alone, where I believe that my client is innocent. I think judges are very mindful of the fact that, or when there is a strong argument that your client is actually factually innocent and not simply reasonable doubt argument, that you want to run it in a judge alone, because I think judges don't want to convict innocent people. I think they go out of their way to do that. So when you have a factually innocent client that you feel that you can probably demonstrate that he's innocent, and this it's oftentimes either it didn't happen case or some kind of significant motive for the complainant to fabricate some hostility or something, or marriage breakdown, and then there's a hostile divorce and there's a backdated allegation that happened during the marriage that never came out until now. Those sorts of things, I don't think if there are no other factors and he's a first offender, it's the type of thing you might want to keep in front of a judge alone, simply because the judge is going to factor in all of that and say, am I really going to convict this person of this sexual assault allegation when they're probably factually innocent? It's the ones that get a little bit more complicated where we have to concern ourselves with the Crown being able to convince the judge that we want to put it in front of a jury. Because the old school philosophy and senior counsel used to tell me a long time ago, it's harder to convince 12 people than it is to convince one. And obviously the burden of convincing is with the Crown, and they have to convince 12 people. And so we're in a situation where, they have a case where they might be able to convince a judge because the judge brings their experience to the table. They might not necessarily convince all 12 of those people on the jury. So that's the type of assessment that we like to do in deciding whether to do a jury trial versus a judge alone trial. And the last thing I think is important conversation to have with your client early is the client needs to understand the inadmissibility of myth-based reasoning. Because oftentimes the clients come in and they, a lot of what they'll tell you and why they feel that they've been aggrieved, if we really listen to what they're saying, a lot of it has to do with what we know as inadmissible myth-based reasoning. And I'll just state that for you. They're on the screen right now. But the one myth is that someone with a very active sexual history cannot be trusted or believed as much as someone who has not been sexually active. And the second is that consent or lack thereof can be determined by the victim's sexual history. So a lot of times clients come in and they'll say, well, you know, we had sex 10 times and there was never an issue, and now all of a sudden number 11 it was a no. Well, we know that it can very well be a no on number 11. That doesn't matter that you had sex 10 times in the past. And they feel aggrieved in those circumstances that you know, that now all of a sudden consent is an issue. But what they're really advancing is myth-based reasoning. And what you have to explain early on to your client is, listen, this is not going to win you the day in court, because that argument is not permissible, because a person can say no on the 11th time. And there's nothing wrong with that. We have to prove that it was on that 11th time that either you were mistaken in the consent that was there, or there was in fact consent. You know, that requires you to make that argument. And you have to make sure your client understands those principles early, because that is going to affect the defense. So if they're, or the other thing is, you know, in cases of human trafficking or prostitution and those sorts of things, that's when the sexual history aspect of it, you know, tends to come into play a lot more. And again, you have to make sure that they understand that the fact that somebody is a sex worker doesn't necessarily make them less credible or less worthy of belief, and doesn't make you automatically right in your decision if you know, had sexual intercourse with them, or you know, some kind of sexual activity without their consent. People need to understand that, because it goes against what maybe they've been brought up to understand or learn, or how society has raised these people. And not everybody really puts these, you know, myths at the forefront of their thinking, especially some of our clients, and especially when they're upset of having been charged with an offense like this. So these conversations need to happen early on, because it might very well be the type of case where your client, you know, based on his, you know, firm beliefs, or if they do have a firm belief or some kind of cultural belief or whatever it is, you know, you might have to tell them, like, you can't testify if these are your beliefs. Even if you were mistaken in that consent on the basis of this belief, that's, you know, that's not a valid mistake. It's either you were mistaken as a matter of law here in Canada, or you were not. And so you need to have these conversations. You need to have them early on, because they're going to affect the decisions you make when you have your client make that election as to whether to have a judge alone trial or a jury trial. And it is the type of decision that your client's going to be involved in based on your advice to them. And so you sit there and you go through all of these various issues with them, and you have frank and candid discussions, and make sure that they understand what they're getting into if they elect to have a jury, or if they elect to have a judge alone. So some of these things arise from time to time, and they arise in my practice too. And, you know, we have to take an opportunity to educate our clients before they make that decision. Assuming that the decision then is made to have a jury trial, we're noticing more and more that Crowns are requesting or applying to have the use of testimonial aids. And they make these requests under Section 46 sub 2 of the Criminal Code, under the basis that it would facilitate a full and candid account by the witness of the acts complained of, or would otherwise be in the interest of the proper administration of justice. And the factors that are set out below in that section of 46.2 are the age of the witness's mental and physical disabilities, if any, the nature of the offense, the nature of any relationship between the witness and the accused, whether the witness needs the order for their security or to protect them from intimidation or retaliation, whether the order is needed to protect the identity of a peace officer who has acted, is acting, or will be acting in an undercover capacity, or a person who is acting, is acting, or will be actively, covertly under the direction of a peace officer, whether the order is needed to protect the witness's identity if they've had or will have responsibilities relating to national security. Those usually don't apply in sex assault cases, obviously. G, society's general interest in encouraging the reporting of offenses and the participation of witnesses and victims in the criminal justice process, and any other factor that the judge or justice considers relevant. So what I'd like to draw your attention is with these applications is the form of the application is important. some courts have said they don't need a full application. They can rely on what they believe is credible and trustworthy evidence. And so what you'll often find is, for instance, an affidavit filed by a VWAP worker. And the VWAP worker will say, well, I spoke with this person, and I believe that, she could benefit, or he could benefit from this testimonial aid. And that may or may not be enough. But what I've noticed is, and what I've done, I've started to do, is I started to cross-examine the VWAP worker and their belief and what they came to their belief on. And one thing that occurred in a case of mine, which I found was troubling, was that the Crown put us on notice that they would be bringing this application, and the VWAP worker had yet to meet with the complainant and then subsequently met with the complainant. So it was already something in the Crown's mind. And what's interesting is, there's a case which I'll just put up on the screen, but it'll be made available to you. It's a case called MT, Justice Conlin, who sits in Milton. And he called out the victim witness person, who was also, by the way, the same victim witness person who was in my case. There it says the Crown called one witness to testify. A person who previously swore and affirmed one brief affidavit, Ms. K. Watt from the Victim Witness Assistance Program in Halton. Ms. Watt was cross-examined by the defense counsel. On hearing of the application, both evidence and submission by counsel was completed in all of 30 minutes. Later on in the ruling, His Honor made an interesting finding here. Let me find it. Where he says, paragraph 14, it's a close call. His Honor states, I'm bothered by what appeared to be a routine practice in Halton of the Crown relying solely on one testimonial aid, that is CCTV. I am bothered by evidence at the hearing that a witness who recently testified behind the screen in another case encountered difficulties doing so. That was a reference to a recent decision of this court where, on similar facts, but a different legislative basis for the application, I denied the Crown's request for CCTV, but permitted the complainant to testify behind the screen. I was there in the courtroom for that complainant's testimony at a trial. There were no difficulties whatsoever, none. I am bothered by the failure of the evidence presented on this application to provide any degree of detail of the complainant's panic disorder and or whether its post-preliminary inquiry worsening had anything to do with the complainant having had to testify in the same room as the accused. So what we get here is a judge making a comment to a certain extent about the VWAP worker's testimony, about their observations in another case for which the same judge was sitting, and her characterization of the difficulty of that other witness being able to testify. And what I found interesting and what triggered for me the challenge to these applications is because if we don't challenge them, we're not, this sort of judicial commentary will not come out. And these types of judicial commentaries come out because it puts the Crown in a position where they're going to have to justify why CCTV, why a screen, why a dog, why a VWAP worker in the courtroom. And we have I know judges and sometimes court participants make us feel like we're being obstructionists when we do these sorts of things, but in a jury trial, these are very important things. It's the way it appears. It's the appearance of that witness's vulnerabilities. If they're sitting in front of a jury and they're petting a beautiful golden retriever as they're crying and testifying, I'm concerned that the jury is going to be more likely to believe that person on the basis that they seem more vulnerable in that circumstances. And I'm going to make that submission to the judge. So in cases where this application is brought, it's a double-edged, it's a two-pronged test. It's one or the other. It could be to facilitate the firm candidate count, or otherwise be in the interest of proper administration of justice. I mean, if the proper administration of justice is prejudicial to your client, then I think you have an argument to say, look, I don't like the appearance of this person sitting there, in this particular vulnerable state, testifying because of how it's going to appear. The same thing with the CCTV. You want to make submissions about the jury's ability to assess the person in the jury, in the witness box, and so on. And if you read through cases on this section, you'll see the various arguments below, various judicial comments on those arguments, and whether or not they've been supported or not supported by judges. And I think judges oftentimes want to just have a normal trial without all of this, testimonial aids and so on, unless they need to. I think their instinct is it's much easier if we just have a normal trial. So challenge these motions. I say challenge them. They're not very complicated to challenge. They're just often brief submissions. If you have to cross-examine the VWAP work, it'll be brief. But what I would say about the cross-examination of the VWAP worker, as is in this case that I just showed you, and I cross-examined the same lady, is what basis does she have other than the word of the complainant, right? Are there medical records? Are there anything to support this? Justice Collin makes that point. It's like, I have nothing. All I have is this woman who's got an issue and obviously is in an antagonistic case with the accused, stating these facts about the impact that this will have on her without anything really supporting it. And even though it is a lower standard of proof for that application, as some courts have found, I still think we should hold the Crown to that standard of proof in these cases, because the concern of how the appearance in front of the jury and how it could be prejudicial to our client. And I think the overarching concern all the time is in jury trials is the appearance of prejudice as well as actual prejudice. We don't want our clients to appear to be prejudiced. That's why we make sure they're dressed appropriately for court. That's why we make sure that the jury doesn't see handcuffs or shackles or anything like that, or armed guards standing beside them or that sort of stuff. We take all these steps to make sure that they don't appear in a prejudicial light. But at the same time, we can't have an appearance of prejudice simply because applications made by the Crown tend to highlight or make the complainant appear more credible or reliable based on a vulnerable state that they're being presented in. The next point is Crown applications under 715.1 of the Criminal Code. So this section provides that video recorded evidence is admissible where the following factors are met. A victim or witness is under the age of 18 years at the time the offense is alleged to have been committed. A video recording was made within a reasonable time after the alleged offense, in which the victim or witness describes the acts complained of. The victim or witness, while testifying, adopts the contents of the video recording. If the above factors are met, the video recording evidence is admissible unless the presiding judge or justice is of the opinion that the admission of the video recording in evidence would interfere with the proper administration of justice. So, you deal with this when you have a young witness under the age of 18 at the time of the allegation. What I've been doing in this case, and when these are presented to me, is you want to assess, first of all, the entirety of the video. You need to assess all of the prejudicial aspects of the video, stuff that would not get in. Because the courts have supported, and I filed a case here, it's a case of DOL, it's a 1993 decision from the Supreme Court of Canada, and I think it's been supported further by another case by the Court of Appeal that slips my mind right now, but it's a more recent decision. But there are several points that you want to be mindful of in challenging these applications, because the court has said they have to be mindful of things like the form of the questions asked of the witness. Was the officer leading? Were they teasing out questions? Were they putting words in the witness's mouth? The interest of anyone participating in the making of the statement. So, was anybody there? Were parents there at the time, and were they, assisting in facilitating the content? Obviously, the quality of the video and audio tape. The presence or absence of inadmissible evidence in the video, that's important, obviously, and the ability to edit inappropriate material. These are in my opinion, two very important factors, because oftentimes there will be a lot of inadmissible material in these statements, particularly with young people, because the officers, in order to build a rapport with these sorts of witnesses, they tend to, go far afield in terms of talking about stuff that's not relevant, talking about things that are, obviously not important to the case, building a rapport, your relationships, family relationships of the person. Like the last thing you want to hear is, this person was 13 years old and they have a dog and they love their dog and their dog died by car accident, or, and dog got hit by a car and so on. You don't want that in, because then all of a sudden the jury's going to know all of this otherwise, irrelevant and inadmissible things about the victim or the complainant and the circumstances, and it could be prejudicial to your client. But also, there could be stuff in that statement that is straight prejudice to your client. Like they make comments or hearsay comments. Oh, I heard that the accused said this to Joey and said this to Johnny and was proud of what he said. Like that's all hearsay. It's not admissible. So you have to really scrutinize that statement. And my suggestion is, when you really, really look at it from that perspective, and now it's so easy. We used to have to highlight the stuff that we said was prejudicial, make 3 copies of those highlights, give one to the judge, and see where we can go. Now you can do it all on a PDF. You just highlight it with a box, you put it up, you give it to the jury, you give it to the judge, you say all of this has to be edited out because it's prejudicial. And if you're familiar with police ability to edit statements and transcripts are one thing, but statements are much harder to edit, especially video statements. In homicide cases where they're compelled to do it by the judge, they get it done. And if you do homicide cases, you realize really how complicated it is to do. It's oftentimes that if the statement requires a lot of editing, the Crown will fold their tent. I've seen that happen now a significant number of times, where the Crown folds their tent on this application because they just don't have the resources to properly edit the statement and make it appear sensical. The other thing is, when you edit a statement, I don't know if anybody's seen an edited statement, it becomes very choppy, it loses its flow, and all of a sudden it's not the way, or the Crown doesn't present it's not the best way for the Crown to present their evidence. So it works to their disadvantage to play that statement. And they might just be able to just lead the witness in chief, get that evidence in the normal course, and it's the way you want it. You want it in the normal course, and then you have total control. So I really encourage everybody to look at those statements, really, really look at them, because you can watch the statement 100 times and think there's nothing wrong with it. And then when you're sitting there and it's being played in court and the jury's watching it, and you see the winces or the sympathies or the reactions of the jury the whole time when that statement's being played, you're kicking yourself thinking, why didn't I apply to edit this statement? So, that I think is the number one, way to get this, to challenge this. But there are also other factors like, a jury, whether it's a trial by judge alone or jury, is a major factor, obviously for these same reasons. Whether the prosecution has been allowed to use another method to facilitate given evidence of the complainant. So, if the complainant has testified previously at the preliminary inquiry without issue in chief, then why now all of a sudden do they need to do that? So these are the things you want to consider. And I really encourage you to consider not letting them just get these statements in under 715.1. Number 4, which is the one that we're all dealing with these days and seems to be a little bit of a hot topic, and I'm by no means any expert in this area of law, but it just so happens that I've had to do a few of these since the laws changed, is this Mills JJ issue and the admissibility of this evidence. Now, the first, we'll start with documents that you're applying to get disclosed to you, which is, under the Mills regime. This is just a rudimentary outline of the steps that need to be taken. But the first question we ask is, should these records be produced? And that's an application to 278.3. And then the first stage would be they go to the judge for review, and if yes, then they move on to the second stage where it gets produced to the accused. So if you believe that there's a strong basis for these records, you should apply for them. Now it's becoming more difficult because used to be that, at a preliminary inquiry, the witness might turn around and say, well, I decided to, disclose 3 years later because, I spent 3 years in therapy and, in discussing this with my therapist repeatedly and over the course of those 3 years or whatever other method, they discussed it with friends or family or whoever and wrote a journal or whatever it is, they might say, they've created this record and now you might say to yourself, well, I want to apply for this. I don't want to see what it says. Or if it's in the context of a workplace sexual assault where they provided statements to an employer or some other investigation that's internal, whatever it is, that information came to you. Usually in the old days, it would come out of preliminary inquiry. You get that information, you have a foundation to now bring this application just to get the judge to review that record. And then the judge, gives it to you. Now, it's a double-edged sword as well, because if those records are nothing but negative information about your client and you're still in that preliminary process, like for instance, it's after preliminary inquiry, the last thing you want is, your judge to know all this prejudicial stuff about your client. In the same way, there used to be that philosophy that, you bring the 276 just so that the judge knows about the sexual conduct of the complainant. That used to be a thing that, defense lawyers would just bring it, even though it was futile, just to put this prejudicial stuff before a judge in the hopes that might get them some leeway. If that's your mindset, then your mindset could cut both ways when you're getting records where the complainant is complaining about the sexual assault for the last 3 years, right? Like you don't want the judge necessarily to know about that. So you have to be, careful. I mean, if you're going to go judge alone, if it's a jury trial, then you have to make a decision on whether or not you're going to use those materials in your trial. But assuming the records are something useful to you, and they've been produced to you and you've reviewed them and they are something useful to you, then you have to make a decision of whether or not the records are admissible. Now we get into the JJ side of the argument. You have to decide whether the records are admissible. Because otherwise you can't obviously use those records in your cross-examination. Even information that you learned from the records you can use in your cross-examination, which is difficult. Now, you might have that same information from your client and only from your client. But the moment I think it's corroborated by records, I think what JJ says, and people might disagree on this, but what JJ might say is you still have to bring the application because it's in those records, and out of an abundance of caution, the best practice would be to bring the application and get the judge's stamp of approval. And the way we see it is that, stage 1 and stage 2 are effectively the same thing. The only difference is stage 1 doesn't involve the complainant, whereas stage 2 does involve the complainant. And so in stage 1, you have to, if there's a determination of the admissibility of the records, and if they are something that can be admissible, then they become admissible under, when their records under stage 2, the complainant can come and make submissions on it. But I want to draw your attention to something tactical when you're doing it in a jury trial context, and even in a judge alone context. What we've been doing is, for instance, if you have mixed records that are 278 and 276, for instance, we had a family court affidavits where we brought the motion, even though we believe that they were public records, there was no privacy interest, and they would be admissible. Within that family court affidavit was discussion of the sexual relationship between the two parties. And obviously that engaged 276. On that portion there, we had to then go into stage 2 on the 276 concerns. We asked the judge for direction to revamp our application so that we could just file a new application identifying the 276 issue only, which was interesting, because what happened, we had like a 12-page family court affidavit, and in our revamped application, it was 2 paragraphs that were provided to the complainant and the complainant's counsel, and we cropped it, and we only provided those 2 paragraphs. We didn't black it out. We didn't show them that there were 12 pages. We only showed them those 2 paragraphs, and by doing that, they were not made aware, and counsel for the complainant was asking me to disclose, the entirety of the family court affidavit because, it's hard, like she wants the full context. And I said, well, no, these are the only two paragraphs that the judge has required me to disclose to you, because these are the only two paragraphs that are impugned. So these are the only two ones that I disclosed. So when the complainant was testifying and, when I cross-examined her on those two paragraphs, she had answers like ready to go, which was obvious. And I asked her, where I was going to ask you about this. And she said, yes. But then when I cross-examined her on all the other material inconsistencies with her version of events and the balance of the 12 pages of the family court affidavit, she testified that she had no idea that I would be asking her about the contents of the family court affidavit, because she didn't know that was, something that I sought to admissibility on. So if you're going to bring an admissibility application and you're successful at stage one, you can apply for direction to be able to just vet the portion that's got to go to stage two, so that the complainant because otherwise counsel for the complainant is going to see the whole affidavit and they're going to say, well, he can ask you about this, he can ask you about that, he can ask you about this. And in that case, I think it was 3 affidavits. So there was plenty to work with, and many, many inconsistencies that were material. So take that step. I know it's a little bit of extra work, but it's not really that hard if you're just shrinking it down. And parsing it to the thing and get the judge's approval to do that. And the Crown is not going to stand in your way, because how can they? This is only the stuff that's relevant. And the Crown's usually just going to say, I'm fine with them just providing the relevant portions and not giving them the whole application. And the other thing that it does is, in your first notice of application, you demonstrate the relevance of all the materials that you're seeking admissibility on. So you're giving up, and a big complaint with this regime is that we're giving up too much and we're reverse disclosing. So when you have an opportunity to you're reverse disclosing to the Crown. So we're stuck with that, but at the very least, you can preserve the reverse disclosure if you can on things that are not deemed records and now necessarily are something that you can rely on. You don't have to, revamp your application. You don't have to disclose it to the complainants and the complainant's counsel. And to the extent that you have a little bit of an element of surprise, you still do, right? So, I think that that's something that you should be mindful of when engaging in these types of applications. The other thing you want to do is you want to be able to have as much information at your disposal as possible, and then you can focus it and narrow down what you want to ask about and what's not. So if there are 4,000 text messages, apply to put all 4,000 in. The Crown the Crown doesn't know which ones you say are relevant or not. They're not going to read them all. Sometimes they will, sometimes they won't. But if they all get in, then you still catch them by surprise, because they're not going to know which ones you're going to use that are relevant. By the same token, you should be mindful that you are giving up, and sometimes in those messages, a lot of stuff that your client is saying. And if your client is going to have to testify, your client's going to have to be prepared to answer to some of their messages that they've sent to the complainants. But these are the types of things that you should be considering in the pretrial application. My view is getting information ready for yourself and at your disposal is important, so you can bring these applications. And the last section I want to discuss for tonight is the jury selection process. It's very important, I think, that you make sure the judge asks the offense-based question to prospective jurors. It sounds something like this. The trial involves charges that include sexual assault. Have you or someone related to you or with whom you have a close connection to being a victim of these named offenses or similar crimes? If yes, provide short, relevant details and indicate whether you have any concern about whether this may impact your ability to discharge your obligation as a juror to maintain impartiality and render a decision based solely upon the evidence and the instruction of the trial judge as to the law to be applied. And then this was copied from a questionnaire where it was a yes or no. If the answer is yes, please explain how. So this, in jury trials, this is oftentimes something the offense is told to the jury at the outset, the entire panel. What judges are doing now is they're creating a questionnaire. And I provided an example. It'll be available to you in the materials of one that a judge has permitted me to disseminate for the purposes of education. So the whole questionnaire is present, as well as a cheat sheet of the jury selection process. So that'll be made available to you for anybody who's interested. But for the purposes of this issue, is you want the judge to provide this question to the jurors. And the questionnaire is really good. If they're going to give the questionnaire, you want it in the questionnaire, because they're sitting there, they're stewing. Everybody wants out of jury duty mostly. The people who don't, you should be, in my opinion, afraid of, right? So everybody kind of wants out. And then you can kind of get a sense of the mindset of the jurors. And what I've been noticing is that, this type of question in a sexual assault case, this is not a robbery or something that's like fixed. In a sexual assault case, the definition of sexual violence or sexual assault is different for everybody. Some people, like I've just noticed that younger people have a much more expanded view. Oh, my lights went up there. They're much more expanded view of sexual violence, right? And so younger people might answer more often than not yes to this question. And for whatever reasons that they feel that they've been aggrieved sexually in their lives, and they won't be able to put that aside to decide this issue. Some other people of different generations might have a more concrete definition of sexual violence. They might associate it with rape, only rape, and not what we know today is, the broad scope of what a sexual assault is. And so for them, when they might answer no to this, because they even though they were probably the victims of sexual violence by our definition, it didn't offend them in such a way that they're not going to be able to set it aside. They don't even recognize that it meant that their personal definition. But what all of this does is, given that we don't have any more ability to challenge prospective jurors, just because of preemptorily as we used to, it gives you a little bit of insight into their mindset. And I'll be frank, there was a juror who said yes, not me, but a person that I was close to, but I'll still be able to decide this case. I think I'll be able to set it aside. So that's good. I've had another person say, yes, my father was falsely accused of sexual assault, and he had to go through all of this and have a trial. And by the end of it all, he was acquitted, but it was a big ordeal. But yes, I'll still be able to set my that aside, because the judge will ask that, and like that came out of Chuhan. And are you able to set that aside? It even goes all the way back to Park. So can you set your prejudices aside and apply the law? And you want that little bit of insight into that juror's perspective mind, because this way you at the very least know. And if they really just want out of jury duty and they say they can't set it aside, then it's going to be hard for a judge to say, well, we're going to keep them on. So the other thing it does is that it gets rid of the jurors who really don't want to be there. And the way it's happening right now, that's all we got left in jury selection. So this is an important question that needs to be asked. It provides you a little bit of insight, and you have to make sure that it's asked, because even though this questionnaire is very popular in Toronto, it's not necessarily popular in other jurisdictions. Even though this phraseology forms its way into part of the judge's opening, when the prospective juror gets up there, they're not thinking about it necessarily. They're thinking about, well, I'm going to use my vacation as an excuse, or I'm going to use my inability to sit comfortably for a long time as an excuse. They're not thinking that this is going to be their excuse. But if you insist on the judge, that the judge iterates this for them and says, answer this specific question. And if you notice on the questionnaire that I provided, this is one of the last questions asked. So it's once all their excuses are gone, they come to this one. And usually, even in a case where there's no questionnaire, but the judge is asking the question, this is the question that they ask, because even the judge has a little bit of an interest to assess whether or not there are any biases. And if those biases exist, then if they can be set aside and judge the case impartially. So I do encourage everybody to apply, if it's not part of the judge's opening or part of the judge's jury selection process, to apply to have this as being part of it. And you can, I don't know if you can rely on the questionnaire that I provided, but it is practice in this jurisdiction. Judge authorized me to disseminate it, so I did. And you can ask other judges to do it too, because it's important. The other thing I've noticed about juries since we've been denied the preemptory challenges is younger jurors in the last 4 jury trials I've done, have all been the 4-person. And it's something weird. We used to always think that the 4-person would be an old man or somebody more senior who could kind of bring everybody together. And it's turned out that it's been younger jurors, which is it's nice in the sense that everybody in the room is kind of deferring to that young perspective. And the young perspective, while everybody says, they're, let's say millennials or whoever, younger people are more fragile and find themselves to be victims and so on, I think that they really take the second part. I'm just going to continue in the dark. It might not turn on. I think you have to go out in the hallway. Anita, do you know where it is? Yeah. Okay. Anita's going to take care of it. I'll just lean in. Hold on.
I'm giving you a spot.
I think I might have a light here on my phone. All right. So the younger jurors, they do take that obligation to be impartial and set those biases aside very seriously, I think. And I think what happens is those older jurors who might have, firm and fixed beliefs of how things are in the world, I think that they are a little bit afraid to dig in on those beliefs in the face of younger jurors who are more open-minded to different perspectives and are more considerate of the judge's instructions as to why they should follow the law and set aside their biases and their perceived biases. In one jury, I'll just tell a side story until Anita can get the lights on, then we'll open it up. There it is. Well, I'll just tell the story anyways. One juror on a race-based question, said, because now the race-based questions ask about biases and perceived bias. And one juror said, well, no, I'm not racist. I have Black friends. And then they left, and the unconscious bias. And I said, Your Honor, isn't that really the definition of unconscious bias? Like, they make a comment like that, and they don't realize that such a comment is not actually supportive of a person's not racist. It could be, but it's not. They're making it in terms of in support of their position. So, you want them talking. Get the jurors to talk as much as they can, and then they might give you something that you can, because you can still challenge them on their section. I forget the section off the top of my head, but it's a challenge for cause section of the criminal code. I think it's 683 or something like that. And you can still challenge them for not being impartial as between the accused and the queen. And if they say something that leads you to believe that, you can make submissions on that point, and you might get a juror excluded on that basis.
The king. Yeah, not the queen. Yeah.
Oh, I'm sorry. I haven't done very many Rex trials yet. So for tonight, everybody, that's the 5 talking points that I wanted to hit. And I went a little faster than normal because we did have a late start. But if anybody has any questions on these points, I'm happy to address them now. We do have some time.
Yes, and thank you, Marco, for this presentation. So if you have any questions on the Zoom, you can either type them or ask Marco directly.
Hi there. It's Rebecca Gill. I'm a young lawyer out in BC, and I've done a few of the 276, 278-3 applications, and I was quite interested when Marco was talking about adjusting the application before sending it to the complainant and their counsel for stage 2. I'm wondering if you could speak a bit more about that and what your experience has been. Have you ever had any pushback? What types of things do you consider when you're vetting it?
So what I recommend doing is the portions. So if you have records that are, is it possible to keep your camera on, Rebecca? Because I feel like I'm talking.
Yeah, totally. I was like, there's a baby running around. I'm going to mute myself in case she decides to make an appearance.
Sure. If there are, just for this answer, and then you could turn it off. If there are portions of the record that are deemed to be not records, hypothetically, that don't engage 276, but you have to bring the application out of an abundance of caution, and you're demonstrating the relevance of it for the judge. It might be motive to fabricate. It might be animus that they've developed. For instance, he smashed the car and didn't pay for it, and it's all explained in the text message, and their anger and so on. And the judge says, well, this is all fine. You can cross on all this. But there's also text messages or there's also information in those messages about their sexual history that you want to be able to ask on, but they do engage 276 now. That's not going to be okay. And the Crown's going to hold you on that. So you have to move to stage 2 on that aspect of the record. On that aspect of the record, you craft a new application only focusing on that aspect of it. Because that's the impugned aspects. That's the aspect the judge is saying you move to 276. So you move to stage 2. So because that's all that you're moving to stage 2, that's all you're providing. So what I recommend you do is you advise the trial judge, at the end of that application, because he's still making a ruling to some degree saying, all of this is fine. This is not, this is going to stage 2. You say to the judge, Your Honor, at this point, I'm going to apply to the court to be permitted to amend my application only to focus on the parts that Your Honor has indicated are moving to stage 2. I'm going to amend it. I'm going to reserve the Crown, and then serve the complainant with the amended. So it's no prejudice to the Crown because the Crown has the full. And the complainant doesn't have to answer to the other stuff because the other stuff's not relevant. So they only have to answer, or they only have some standing to answer or to make submissions on the portions that the judge say they do have standing on. And so basically by doing that, you're not tipping off the complainant as to all the other aspects that you might want to cross-examine on, and the explanations for that cross-examination that you've given to the judge and the Crown during your notice.
That makes sense. And then, that's really helpful. And so then at stage 1, when you're serving the Crown, I know Crown has the discretion to not necessarily provide all the details to the complainant's counsel. They don't need to be served with a full application at stage 1. They can just be informed so that they can retain counsel and get instructions. I've had a few Crowns say, well, I want to provide the full application to complainant counsel.
Right. That's a good point.
Stage 1, which is a tricky thing to navigate. And I know JJ gives them a bit of room, but I'm wondering about that as well.
You're right. You're right about that. Sorry, I forgot about that. It's a good point. Yeah, no, I always ask the Crown to not disclose it. And if they're adamant on disclosing it, then we got to bring a motion before they do that and get a judge's direction on that. But I've had no pushback on not disclosing the stage 1 at this point, because I don't see any reason why. I haven't had a case where the Crown has been able to justify a stage 1 disclosure. So I haven't had that step, but I always ask them. And that's something that I should have put in my materials, that you should always make sure that the Crown does not disclose it unless you cross into stage 2 or you get a motion for direction from the judge. I'm not trying to disparage Crown attorneys here, but they got a lot on their plate, and I don't feel like they want to bring a lot of extra work. I don't see them bringing these motions for directions on things like this, if they know, well, let's see what the judge says first. And if the judge says yes or no, or what has to be disclosed, then we'll worry about it then.
Okay, great. Thank you so much.
You're welcome. So Sharon Saburin has a question here. It says, what are your thoughts about challenging while the prospective jurors or body of jurors listens to your objections? No, that's a good question. And I always have the jurors excluded. So I walk through the process with the judge beforehand. I'm just going to do a quick look at I think I can share it here. Yeah, so it's under 640 sub 2, exclude the panel of sworn and unsworn jurors until challenges get resolved. So it's number 6 on my checklist that I'm providing in the materials. I always have the whole panel excluded. I don't want other jurors to hear my objections to anybody for any particular reason, just because I don't want them to think, they develop any perception of me and my submissions. And frankly, judges, what they do is they ask the question of the prospective juror, then they'll say is, counsel, I'm going to look to you. If I see somebody rising, I'll ask the prospective juror to leave. They'll just think it's part of the process. Or if I don't see anybody rising, I'll just say that's fine, and we can move on from there. So, or sometimes they'll just say, automatically ask every juror to step outside. Any submissions, no, bring the juror back in. So that as far as the juror is concerned, there's nothing untoward about the process. And so in the following question that Sharon's asked is, here no one is excluded while you're debating the issue. And my fear is that if I'm not successful, the juror now dislikes me. And that's the valid concern. And I hope I answered your question. You apply to the judge to have the jurors excluded for that very particular reason. They don't need to hear legal submissions. They don't often hear any legal submissions in a jury trial. They might hear some if there's an objection and so on. So you have every right to ask them to be excluded for fear of prejudice to your client. And typically in jury trials, I make every complaint. I just say it prejudices my client's fair trial rights. Every complaint is going to start with prejudice my client's fair trial rights, so that it's always puts it on the judge on notice that this is why I'm complaining. Sam Pachala, can you break down how you use a prelim transcript when putting them to witness before the juries and how it may be different judge alone? For example, I have had a witness deny. I'm going to stop here. Sam, this is going to be in part 2. I would like you to send me an email with this exact same question if you can, and I'm going to make sure that I address it when I'm talking about, because this is something I was going to talk about in part 2. So if you send me this question in an email, I will make sure it's part of that process. I have Ms. Chowdhury here with a question. Hand up. Go ahead.
Hi, yes. First of all, thank you very much for this session. I think it's very, very useful. I have actually 2 questions. So what's your view on whether or not we should select a jury trial when it's a very, very small jurisdiction and a small community? And my second question would be, what would you do if you feel that there is indication that the Crown, I mean, it's a big allegation, but if you feel that the Crown is actually coaching the complainant in some way to provide a better statement in the court?
All right, 2 questions, completely different. The first one, in the small jurisdiction, I mean, you have to know your audience no matter where you practice. Obviously, if I have a case in a jurisdiction, I had one in Windsor. At the time prior to making an election, I reached out to Windsor Council. I said, is this a jurisdiction where I should take this upstairs? Is it a jurisdiction I should take it downstairs? What do you think? Here's the case. Here's the facts of my case. I reach out to people in jurisdictions that I don't practice in before, so that I can advise my client. And then I just tell my client, I contacted counsel there who do a lot of cases there. They say this is the type of case that we should keep in the provincial court. This is the type of case we should take into Superior Court. Some places will tell you the provincial court here is not very good. They're convictors. Take your chances with a jury, etc. Some of them will say, no, we have a great provincial court bench. That's why we keep everything downstairs, and only very few cases go upstairs. So you want to do your research in that way, and also obviously your standard research in terms of, look at the judges in that jurisdiction, and then just do your research on Quick Law or Canley and see their rulings and how they've decided cases that are similar to your cases. On the question of Crown coaching, that's a much more complicated question. Any allegation of Crown interfering with a witness's testimony is a very serious allegation. It could result in remedies pursuant to Section 7 of the Charter for abusive process, etc. The big issue you run into is obviously proving these allegations. They're not things that you just make, willy-nilly and without any evidentiary record. The difficulty is getting that evidentiary record, unless the complainant says, I met with the Crown and the Crown told me to say A, B, and C, and they might say that. But even when they do say that, I always give the Crown the benefit of the doubt, because it might very well be that the Crown is or the complainant's understanding of what occurred is different than what actually occurred. Most of the time, Crowns don't meet with complainants alone. There's always a police officer present. And if there is any meeting with Crowns and the complainant, usually you should ask for notes of those meetings to find out what in fact occurred at that meeting. And if the Crown did or said anything untoward. And at the end of the day, there's nothing wrong with asking the witness, well, I know that you met with the Crown the other day. Yeah. And what happened in that meeting? That meeting is not privileged. And they can tell you oh, they just told us that I'm going to be testifying. I'm probably here on Monday and Tuesday, and it's going to take 3 hours, and you'll ask me some questions and so on. Or they might say something that you might need. And when you get that information, you have to decide what remedies, if any, are available to you if there's been any prejudice to your client. But as officers of the court, my recommendation is always give the benefit of the doubt to the Crown. They're lawyers. They went to school. I don't feel that very many of us are going to put our own reputations like that on the line for a case. I mean, I know we get into the heat of battle and sometimes we might, or think that the other side might, but give them the benefit of the doubt until you can show or prove, or you know for sure that there's something more to it. And then even when there is, the first thing is to, put them on notice, provide an application, put them on notice, and explain how your concerns and how you're going to approve it, and then go from there. Okay.
Thank you very much. Very helpful.
You're welcome. Sure. So I got Gail Smith asking if there is a family court affidavit that does not include statements of their sexual history, but otherwise has information that can impugn credibility of the complainant. Is it necessary to bring the application in order to use it, or can you surprise them by putting details to them and cross-examine without disclosing the affidavit to them? My instinct was exactly that in the case that I did, but I mean, I had the 276 issue, so I had to do it, but my instinct is that you don't need to do it. It's a matter of public record. You shouldn't have to do it. I mean, JJ seems to say, in an abundance of caution, you should do it if you don't know for sure, because they're in the jurisdiction. It wasn't my jurisdiction. Client costs. The last thing I wanted is mid cross-examination to have to adjourn a trial, come back just because I've decided to put this in at this point in time rather than give anybody notice. Because what we're going to know, and what we'll talk about more in the next session, is in the middle of the case, 276 and 278 issues arise all the time, and now you have to make decisions as to whether or not you want to go down that road. But instinctually, I don't believe family court affidavits require the application. They're a matter of public record, and there's no privacy interest. So you should be able to cross-examine on them if there's no 276 issue. But you got to factor in a complaint from the other side, which might delay the proceedings. Is there another? Oh, yes.
Yes, I have 2 questions, and one actually directly relates to that. So it's kind of a good segue. What if you have text messages, for instance, which aren't as they're not public records. They don't have any 276 implications, and in your mind, they don't really go to the JJ considerations. It doesn't go to their personal dignity or anything like that. If you have that in your mind, and you still want to surprise, what happens if you get to trial and the judge says, "Oh, well, I disagree with you"?
Well, that's why I think that, not that I'm happy about JJ, but I mean, at the very least, in the first stage of JJ, you bring that first stage, you're obviously tipping off the Crown. But if everything you say is accurate, so if anybody didn't hear the question, it's, if the messages don't engage the principles in JJ and you want to use the surprise, but you run into an issue when you do that the judge disagrees or requires you to bring the application at that point. I mean, my position is that's why you should bring the application out of an abundance of caution, because yes, we are stuck with tipping off the Crown. But if you win it at stage 1, then you're not tipping off the complainant, in the sense that you're demonstrating that this does not amount to a record that needs to be disclosed, and the complainant does not get the opportunity to do that. And then it is the factor that you have to consider in terms of, is the cost to the client. Do you want to risk, some clients will be like, drag this out as long as it matters. So your case blows up in the middle of a cross and it just comes back in 6 months and you continue your cross from there. If your client is basically saying, I want to get this over with, and you've booked a 2-day trial and you know that this is going to put it off the rails, then these are the types of considerations you might want to make in advance, because you know how you're going to use them. The other side doesn't really know what you're going to make of them. Oftentimes they're in support of your defense.
The second question I have relates to 276 and honest but mistaken belief.
Yeah.
So if we're dealing with, you oftentimes get the example of like BDSM type of behavior, that sort of stuff.
Mm-hmm.
and you have a complaint that's like diametrically opposed, how do you use that in the 276 context where a Crown is going to say, well, consent doesn't have to do with what's in the accused mind, it has to do with what's in the complainant's mind. So like, how do you kind of cross that with 276 and potentially patterns of behavior going into the accused minds into honest mistaken belief?
Yeah, that's a very complicated factual issue that it's funny because I'm kind of got a case like that right now. In the case that I have, the text messages do support both parties engaged in that type of, it's BDSM behavior, in which case, there is that basis for that. As I see it, there is a basis because the accused can then say, well, she said, do this to me, and I did what she asked me to do. And then after the fact, she's saying, well, no, I never agreed to that. So there is that basis to do that. But in a straight application like that, you're likely going to have an affidavit from your client at the motion, at the stage 2 of the motion. Like in the first stage, you can write an affidavit of information and belief, indicating why you believe this is relevant and where it goes. And if you cross that stage, then you're going to have an affidavit from your client. You're going to have to prepare them to testify. And it's good if there is support for those propositions. If there's support for those propositions, because then you can, basically you're running your trial. If it's a judge alone, you're running your trial at that point almost, because your guys getting the box judge is going to know what his defense is, and it's going to just assess the complaint on that basis. In a jury context, though, it gives you a first run at your guy testifying, preparing to testify, and explaining his version of events, and then whether or not, I know what your question is if it's in his mind but not in her mind, if it's something, but if it's a one-off, if they've never engaged in it and then all of a sudden he's using that as his defense, it's going to be more problematic. If you do have an evidentiary history of it, and that's why you need to lead that 276 stuff, it's because there is a history of it and it's supportive of your client's position. And so, it's complicated. I'm worried about it in this current case that I have as well, but you're going to have to roll with that, because we don't know how. It's very hard if you're not engaged in that subculture, how a jury is going to understand that subculture and what they're going to do with it. They could prejudice the accused for engaging in that. They could prejudice, the complainant for consensually engaging in that on some occasions, but not on other occasions. Right. And in which case both parties are being, and there's some negative connotations that support, that could go against both people. It's complicated in a jury situation. That might be a judge alone. Like in the case that I have, I'm considering a judge alone just because of that. I don't want any, worrying about members of the public coming in saying, I don't understand, like, whips and, ball gags and so on. 8:24, I said I'd stay till 8:30.
No, we don't have any questions.
Anita awarded me with the Wicked Ally 2023 award.
It's from WiCCD, all of WiCCD, the executive of WiCCD, the organization of WiCCD, and it's 2023's annual WiCCD Ally Award. The only other recipient was John Struthers, and Marco's this year's recipient. So it's second recipient ever.
Thank you so much. It's the only award I ever got in my life.
Well, it's the first of many.
Thank you.
And very well
I'm
deserved.
proud of this. I'm going to put this right
It's
here
beautiful.
on my bar.
Thank you. Marco.
Thank you very much, everybody. And we'll see you on October 4th for the part where you guys have questions. If you have any questions about the execution of things in the jury trial, please send them to me or Maya, and I'll do my best to address them in my talking points, because otherwise I'm just going to go off the things that I've been considering.
And we will circulate the materials as well as soon as we get them.
Next week.